5. Justice in the courts. In March of 1980, a sheriff and his men arrested the pastor of a church in Mississippi. The Reverend Herman Fountain was pastor of the Bethel Baptist Church and Children's Home near Lucedale. The Children's Home sought to rehabilitate children or to provide a home for homeless children. No child was kept against his wishes, and the honour system prevailed. A 15-year-old boy, 6 feet tall, about 180 pounds in weight, had just been placed in the home. Pastor Fountain had told the unruly boy either to keep the rules or leave. The boy took off, was picked up on the highway by the sheriff's men at 3 a.m. and 4 a.m. and claimed he had been whipped. Without an investigation, the sheriff, some of his men, and a welfare department employee went to the church at 11 a.m. on Sunday morning to arrest the pastor. The assistant pastor was also arrested, the service shut down, and church records confiscated. All the children in the home were taken and stripped to see if they had any bruises. No criminal action was proved or prosecuted. The state required minor changes of the home's facilities, most of them already planned or in progress, and asked Pastor and Mrs. Fountain and 3 other defendants to sign a release form stating that they would take no civil legal action charging violation of their civil and or constitutional rights before they would agree to drop the charges. What was unusual in this case was that the court apologised more than once, according to reports, to Pastor Fountain and the others. Godly and innocent men are regularly subjected to legal injustice and harassment without any apologies. This Mississippi court was unusual in that some apology was made, and it deserves commendation for this fact. What was usual in this case was what the release form represented. Our courts are agencies of county, state, or federal branches of government. They have come to represent and defend not the freedom of the people or their interests, but those of the states and its bureaucracy. As a result, the courts represent less and less a resort for the people in their appeal for justice, but more and more a statist resource against the people. A very high percentage of the cases heard by the higher courts represent appeals by some branch or agency of state against the people. We can be grateful in this situation that there are more than a few judges who vindicate the appeal, but the trend is towards the vindication of the state. Marxism holds openly to the belief that the law and the courts must represent a class interest. The charge against us is that our courts represent the capitalists against the workers. The theory behind our judicial system is that the court and law must represent justice, not a class or the state. The state cannot be identified with justice. All too often in history, past and present, the state has been the source of monstrous injustices. For a court, thus, to protect any bureaucracy, agency or officer, and to cooperate in a release form which exempts all such from the rightful penalties for their actions is wrong. The court has no right to represent the state or the people. It must represent justice.